Hello students, how are you? I hope you all are fine. In the earlier video, we discussed about the meaning of triple talaq or talaqul biddat. Now in this second video, we will know about the constitutionality of triple talaq. This institution of triple talaq, which was practiced in Muslims up till now, up till 2017, was a matter of hot debate in the Supreme Court of India. It involved Government of India, Supreme Court of India. Many writs were filed against this type of divorce by many stakeholders, many people belonging to different faiths in India. And finally, Supreme Court in 2017, in a famous case of Shaira Bano versus Union of India, declared this divorce to be unconstitutional, illegal, and totally void. Before discussing that, we should know that India belongs to different people having different faiths, different religions. They are governed by their own personal laws. Muslims are governed by their own personal law as far as marriage is concerned. The personal law which governs Muslims' marriage is the Muslim Personal Law Shariat Application Act 1937. This Muslim Personal Law Shariat Application Act 1937 has declared or authorized this this triple talaq. It is totally legal for a Muslim husband to pronounce triple talaq upon his wife, and this Shariat Application Act 1937 declares it to be totally legal. Now, this Shariat Application Act 1937 itself has been challenged in the Supreme Court through various writs, and finally, the Supreme Court of India in Shaira Bano versus Union of India 2017 declared this triple talaq to be unconstitutional, and as far as Shariat Application Act is concerned, it is totally void as far as it relates to triple talaq. Otherwise, it's totally valid, but as far as it legalizes triple talaq, it is void up to that extent. Now, in Shaira Bano case, at least 5 judges sat, and they belong to different multi faiths, and Honorable Supreme Court, by the majority of 3-2, 3 judges were on one side and the 2 judges were on the other side. So the majority opinion was of the 3 judges. So the 3 judges, that is the majority opinion, held this practice of triple talaq to be unconstitutional, to be void and illegal. It described triple talaq as manifestly arbitrary, as it allows a Muslim man to break down a marriage whimsically and capriciously. So triple talaq is unconstitutional under Article 14 of the Constitution of India, read with Article 13, Clause 1 of the Constitution of India. The court said that Muslim Personal Law Shariat Application Act 1937 is void to the extent that it recognizes and reinforces triple talaq. So why this has been done by the Supreme Court? Because in Article 13 of the Constitution of India, 13 Clause 1, it was said that any law which was in force in the pre-constitution era, obviously this Muslim Personal Law Shariat Application Act was passed in 1937 during British era. So any pre-constitutional laws, constitution was enforced in 1950. This Shariat Application Act was passed in 1937, way prior to 1950. So any Article 13 says that any pre-constitutional law which violates any of the provisions of the Constitution, it has to be declared to be void. So this Shariat Application Act actually violated Article 14 and Article 21 of the Constitution of India, because triple talaq has been declared to be void by the Supreme Court. So as far as Shariat Application Act is concerned, it is also totally void as far as it legalizes triple talaq. Otherwise, it is totally valid. Shariat Application Act is totally valid, but it is void only up to the extent that it recognizes or it legalizes triple talaq. So the court, after reviewing the relevant precedents and Islamic scholarship, concluded that the triple talaq is not essential to the practice of Islam, and following this judgment and on its own initiative, the Government of India issued the Muslim Women Protection of Rights on Marriage Ordinance 2018. And after this ordinance was passed, then the government of India enacted the Muslim Women Protection of Rights on Marriage Act 2019. Very important act. I again say, the government of India enacted the Muslim Women Protection of Rights on Marriage Act 2019. And this act actually criminalized the triple talaq. The act had following provisions. First, any pronouncement of triple talaq by a Muslim husband upon his wife by words either spoken or written, or in electronic form, or in any other form, shall be totally void and illegal. And any Muslim husband who pronounces this type of talaq upon his wife shall be punished with imprisonment for a term which may extend to 3 years, and shall also be liable to fine. The wife shall be entitled to custody of her minor children in the event of pronouncement of triple talaq by her husband in such manner as may be determined by the concerned magistrate. The offence of pronouncing triple talaq is cognizable, that is, if information relating to this offence has been given by the Muslim wife herself or any of her relatives to the police station, then this police station has to record an FIR, file an FIR, and this offence is also compoundable. That is, if the married Muslim woman wants to compromise during the trial with her husband, she can compromise, but with the permission of the court, with the permission of the concerned magistrate. So it's a compoundable offence. As far as various countries are concerned, along with India, which has declared this type of talaq to be illegal, is many Islamic countries like Bangladesh, Sri Lanka, Saudi Arabia, Turkey, Egypt, Sri Lanka, Iran, and even Pakistan has also declared this type of talaq to be illegal in their own countries. So now India has also declared triple talaq to be illegal. Now, if any Muslim person pronounces triple talaq on his wife, then he can be put behind bars for maximum of 3 years. So this type of talaq is banned now in India. No Muslim person can pronounce this type of talaq. But the other two forms are totally legal. That is talaq ul ahsan and talaq ul hasan. They are totally valid, totally legal, and they can pronounce talaq in that way, but not in this way. So what is talaq ul ahsan and talaq ul hasan? That I have discussed in detail in the earlier videos. Check out those videos. They're very important for your judiciary as well as other legal exams. So I hope you like the lecture. Thank you very much. Do comment on my videos so that I can learn from your comments and I could put or post more and more videos for you. Thank you very much.